All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Thank you, and welcome to this special session of the Appeals Court for Monday, April 7th, 2025. We're hearing just one case, and that's Commonwealth versus Anthony Freeman, 24P274. Your panel today is me. I'm Greg Massing. You have Justice Neyman. It's pronounced Neyman. And Justice Wood. Each side gets 15 minutes. There's no rebuttal. We have read your briefs. We're familiar with the case, so you can just jump right into it. There's no penalty for finishing early if you've said all you need to say. So we'll hear from attorney. How do you pronounce it?
Warius.
Say it again.
Michael Warius.
Warius.
Yes. Good afternoon. I represent Mr. Freeman, and today we're on appeal from a Rule 30B motion out of the Suffolk Superior Court. It was a motion to vacate habitual offender convictions. The case came about a little bit unusually, I guess. The defendant was convicted after a jury trial, and there was a break before the habitual offender trial began. During that time, a deal was offered by the Commonwealth, which Mr. Freeman told his counsel he did not want to take. That decision was influenced by the ineffective assistance of his trial counsel, as well as certain statements made by the trial judge at the time that gave him solace and confidence in that decision. The motion judge made several findings that I feel were not supported by the record and ignored findings that should have been made from the record itself, abusing her discretion and requiring that her decision to deny relief on the Rule 30B motion be overturned. One area of major concern for me is this idea of labeling an affidavit of a defendant self-serving without giving specific reasons from the record about why it is self-serving. Here, the reasons that she gave, none of them are supported by the record at all. The first one was delay. Now, delay in this case was not attributable to the defendant, that trial counsel could not identify his own effectiveness, and he didn't tell predecessor appellate counsel about any sort of defect or error with the plea process. Appellate counsel provided an affidavit in support of our motion, and she indicated she didn't observe this issue as objectionable, but if she would have, as she does now, she would have raised it.
So you're arguing that a issue is not, a person is not on constructive knowledge of an issue unless they're told specifically by a lawyer that there's an issue?
No, this was an issue that the defendant, I'm arguing, had no part in the delay of bringing this forward because it had never been raised before through counsel's ineffectiveness in the past. He was represented at all times in the proceedings before until I was his attorney, and this was not an issue that came to the forefront.
Well, there was an ineffective assistance claim brought in the first appeal, correct?
Correct. And that was Attorney O'Connell, and she's the one who averred that she did not observe this issue. And if she would have observed it, she said she would have raised it at the time, but she did not, unfortunately. And that Mr.
So what stopped her from observing it?
Meeting the standard of ordinarily fallible attorney.
So she's ineffective for not recognizing it? So
That's
both
correct.
you got trial and appellate counsel?
Correct.
So let me ask you this. What should his trial counsel have advised him?
His trial counsel should have advised him about...
And an ordinary fallible lawyer.
Right. I mean, in the motion below, I laid out the progression, I feel, from Strickland to today's courts, and principally, I'd say Clark, the SJC, that the gatekeeper for independence and what drives the ineffective assistance of counsel claims is what's the professional norm, what's the standard of the profession. And CPCS lays out in their performance standards.
Just give me just what should he have said?
He should have gone over with him, what a right of appeal is, what the appeal process maintains, whether or not that there were any appellate issues that he had observed during the course of the trial, and explain to him that these are the rights you have. Now, Mr. Freeman had not been to a trial until this case. previous convictions he had pled guilty in all of them. So this was new to him. He needed to also know...
So, I mean, one of the things the judge discredited was, I can't believe that the counsel didn't tell him anything about an appellate process.
Right. I think there's an unusual nature of this case, as I mentioned, is that this plea comes after a trial. This is not the lawyers in the lobby in the morning trying to resolve cases and take them off the trial list. This is a different sort of scenario where I think Attorney Anino, if you look at his affidavit, he had the opportunity to place in there what his practice was at the time and what he usually did in these instances. He did not. And I think in this instance, that part of the case was lacking, that he conveyed what the Commonwealth's offer was, and when he conveyed what the offer was, and him and Mr. Freeman Mr. Freeman disagreed about accepting it, that conversation was brief and stopped there. There's nothing in the record to suggest it went farther.
I have a different question about when you're trying to make this strategic decision, whether I should take this deal, and I guess embedded in your argument is I need to know how good my appellate arguments are that I'm waiving, and Attorney Anino's job is partially to tell me how good my appellate arguments are. One piece of it is also my ineffective assistance claims against Attorney Anino. And that's impossible. He can't possibly get unbiased, and I think you had a footnote in which you essentially acknowledge that. But that seems to me to be crucial to this, that Anino can't possibly give him the advice he actually needs. If your test is, in order for him to make this determination, at that moment, he needs to know the strength of his appeal of the trial that's just occurred. He can't possibly know that unless and until he gets unbiased counsel, Attorney O'Connell, who's going to come along later. So how do you get around that problem?
Well, he also has to weigh the likelihood of success he's going to have at this new proceeding, this habitual offender proceeding. And conviction was a certainty. I think in this case, I don't foresee my sister standing up and saying that their case was not strong, eviction was not a certainty. I mean, he was the person who had twice been in state prison before. He was going to be convicted as a habitual offender with certainty. So the question would be for him to weigh, do I have enough information about appellate issues I could raise to overcome this idea that I'm now going to be in a certain life sentence? Or I could avoid that certain life sentence by taking a risk on appeal. But at this point, Attorney Anino obviously didn't convey anything to him or anything later to predecessor appellate counsel. Appellate counsel found those issues on her own. So it's a balancing. I mean, it's going to have to be a weighing, but he should have all the options available to him and an understanding of the consequences. And when we look at the record, one of the areas I think here that's the record corroborates his claims are in the transcript itself. The judge notes that he doesn't seem to be understanding what's going to happen at the habitual offender trial. He says things to the judge like, I'm trying to find out what happens at the trial. I'm trying to find out right now what it is. And the judge says, I don't want you doing something unless you completely understand what's happening. And this all occurred after he had met and discussed the offer, Commonwealth's offer with Attorney Anino. And my concern from that is that he didn't understand all the consequences of going forward and preserving his right of appeal by having a trial and facing certain conviction. And on the other hand, if I did plea, what am I losing? That wasn't clear to him. And that comes right from the transcript. And that bolsters what he says in his affidavit. It bolsters his claim in this issue. Now, the motion judge paid no deference whatsoever and mentioned that not once in her decision. And I thought this was very key, that there was confusion noted in the record. And they actually let the case go to the next day for him to have time to thinking about if he wanted to waive a jury or not, is what they said. But
do you think it's really credible that he's got this conspiracy theory going in his head that they're trying to cover something? They want me to waive appellate rights because they probably, there's something wrong that they're not telling me. And if counsel had said, oh yeah, no, you got nothing on appeal, is you think he's going to buy that? Or is he going to, come on, people, you're in on it too. Like, is there really a realistic opportunity that he would have taken
I think
that
so.
deal?
I mean, I think information is important. And I think if counsel explained that a waiver of a right to a right of appeal is lawful and permissible, that it happens in the courts. I don't know how regularly it happens anymore, but at that time it seems like it was happening occasionally, that there's something that happens and it's part of the negotiation process, and it gives you a chance to avoid a life sentence. Now, on the other hand, if you want an independent review, for instance, of what I've done as your trial counsel or what's happened in the court proceedings, you take that risk of, going to the habitual offender trial and facing certain conviction. So, I mean, I think it's an information aspect where you have to be able to know as much information as you can to make an informed decision.
Let's go back to Justice Wood's question. Let me phrase it this way. In your client's affidavit, he says that Attorney Anino did not tell him about his likelihood of success on the merits of an appeal. So what should Attorney Anino have advised him?
What I would have told my client is, even if you have a good issue that you think was a good issue, your likelihood of success overturning an order, a decision, is low. It's statistically low. I mean, this court puts out statistics yearly, and if you take out the statistics from, motions to suppress, especially, take out those and just look at the conviction aspect, it's a very low amount. I mean, you're talking about single-digit percentages of success.
Well, he says that to your client, says you appeal, you're probably going to lose, so take the 12 to 15. Your client, 6 months in, speaks to another attorney who says, you have some great issues on appeal. I mean, then we're right back here again with ineffective assistance for telling the client that he didn't have issues on appeal when he did.
I don't think you would be here if a judge who was knowledgeable gave a proper colloquy and the information was put forward into the record at the colloquy that, I've been advised by my attorney, about my rights of appeal. We've discussed it. We've discussed the likelihood of success on appeal, if there is any, or if there isn't any, I guess. But I've discussed these issues, and counsel can certify certainly what was discussed, and the defendant can acknowledge, what information, I guess.
Your argument seems to run anathema to the notion that trial attorneys are often advised that they should probably take a step back and not represent the same client on appeal. You need a fresh set of eyes to look at the case.
But I don't think that would overcome if you're saying that there's a waiver, if there's a knowing and voluntary aspect to a plea, the information you put in the record is going to stop, cases from being overturned. I mean, certainly anything could be filed, right? I mean, the motions are routinely filed with or without merit. So you could end up back here, but
what I'm just suggesting is your argument, I think,
right.
Put Attorney Anino, it's somewhat of a double-edged sword, I guess, is my point.
I'm struggling with the speculative nature of it. Best case scenario, Attorney Anino has a lengthy conversation with Mr. Freeman and says, here are the 3, 5, 7 issues that I think are potential appellate issues. Your likelihood of success on appeal, statistically, sure, is low, but I can't, and he should say this, I can't possibly tell you the statistical likelihood of success in your individual case. Mm-hmm. But then he should also go on to say, but there's a whole other category of possibilities that I can't speak to because I'm biased and conflicted, and that's any mistakes I made. So realistically, I can't tell you in any sense of the word, I can't give you a number about the likelihood of success on appeal. And so I'm struggling, in light of the way you frame this, how you can get beyond that inherently speculative nature of this inquiry.
I think in this case, it probably deserves a little bit less of a detailed to moving the bar forward, because it seems it's a very brief conversation that counsel gets this offer, he conveys it to his client. His client immediately says, I'm not going to do that. I'm not going to take a waiver of my rights. And that seems to be it. That's what's communicated to the court.
And why is it wrong for counsel in trying to pursue client-centered representation to not respect that perspective after presumably a long relationship in which he has a sense better than maybe not you, but certainly better than we do on a cold record of what the client was getting at and where this was going to go?
I don't believe they had an exceptionally long relationship in this case, because Mr. Freeman had other counsel before who ended up taking a different position and having to turn over. So they didn't have such a long relationship, and I think that we don't have any evidence of a detailed discussion between them. What we have is a discussion that appears brief, focused on just what the offer is, and then we have Mr. Freeman's confusion in front of the court about what's even going to happen next in the case, that he doesn't understand even what the habitual offender trial is going to entail, to the point where they say, let's just recess until tomorrow, and we'll figure it out then. And that's where my concern comes from here, is that it seems like on this minimal information, Mr. Freeman did not have enough in order to make a knowing and intelligent, decision. And
Can I ask you another question? The remedy you asked for is specific performance of the
Correct.
plea offer. How do we do that when the benefit of the bargain for the Commonwealth is already gone because he actually got the appeal that he was supposed to waive?
Well, I mean, the case law allows for it that I cited in the Di Benedetto, and the cases cited in there allow for this exact relief I'm asking for. And in the end, Mr. Freeman has served more time in prison and has a lengthier sentence than the Commonwealth recommended. So in one sense, the Commonwealth isn't really prejudiced because the conviction on the underlying charge is still going to stay under the relief I'm asking for. He's going to have served more time in prison than he would have if he took the offer.
For the relief, sorry to interrupt you again, but for the relief that you're asking for, don't you also have to show, assuming you've got over, we've been talking about the first prong of Strickland prejudice, of Safarian. We haven't talked about the second, of conduct. We haven't talked about prejudice yet. And don't you have to show that there's a likelihood that the plea judge would have accepted the deal? And didn't Judge Spurlock's comments sort of indicate he wouldn't?
I think they showed a lack of understanding, and that's how I read it. The motion judge notes that this could be interpreted different ways as a personal view, but he says, I wouldn't do this for anyone, basically he's saying. So I believe he didn't think he had the authority to do it. That's what seems to be in the wording that he said. I don't see it the same way that the motion judge is interpreting as more broadly. But even if he did, I think the attorney could have brought forward to him, the case law, like Commonwealth versus Pike, for instance, I cited below, that, says this can be done with a proper colloquy. And it's a permissible right that you can waive. And I think if counsel argued that, and I did argue counsel was ineffective for not correcting the motion, the trial judge on that issue, but if it was argued more forcefully, I think the judge may have accepted it, because there was a benefit to be gained, by waiving your right of appeal in this instance. Now, I would like to say, though, I don't think that requiring someone to waive their right of appeal on a proceeding is something that, is the greatest tool. But does it serve a purpose for the district attorney's office and their case management? I believe it does. And in this case, that seems to be what the motivation was to not, you take responsibility, you forego the habitual offender trial, we don't have to deal with your appeal, and you still serve a long time in prison with a long time probation thereafter.
One more question from me, and I'm sorry, but your client's parole eligible.
Yes.
And the last thing on the record, he actually saw, this is in November of 2023, he actually saw parole a couple of weeks ago. Did he get parole?
He has been paroled now, but he still has a life sentence because of the habitual offenders. And he will be on parole for life now. He's currently at the Salvation Army in Worcester doing their program. He had just been released a little bit ago from minimum security, and he's doing well with the Salvation Army.
That's good to hear.
Is there anything further?
Okay.
I'll rest my brief. Thank you.
Thank you.
Good afternoon, and may it please the court. Mackenzie Slyman on behalf of the Commonwealth, asking this court to affirm the denial of the defendant's second motion for new trial on this case. If I may, at the outset, I'd first just like to, I think, properly frame what is at the core of this appeal, which is what is essentially a sentencing recommendation from the parties.
I was hoping you weren't going to say that, because I have to ask you about it. What the Commonwealth offered was that would get rid of the habitual offender indictment. Judge can't do that on his own. That's not just a recommendation. The Commonwealth has to do that.
Correct. The judge could not refuse to arraign the defendant.
Not just a mere recommendation. It's also a promise of action.
Yes, it's certainly step one. But even once we got past that point, we're not in the position, should the Commonwealth have moved affirmatively and said, we're not going to arraign the defendant on the two habitual offender indictments. We're then still in a position where at that point there's no open charges for the court to tie a plea to, where there would be a colloquy triggered. We are now in a position of which we find ourselves in many cases in the Commonwealth of there's been a jury trial and there's been a conviction.
So a sentencing recommendation is non-binding, right?
Correct.
So, you weren't even, the defendant wasn't even then guaranteed that he'd get that offer.
Yes, and I realize I'm kind of jumping to the prejudice prong here, though I agree with the motion judge's determination that the performance is simply not met here. The substantial issue was not raised to that point. But certainly we end up at prejudice, and the defendant has not shown that Judge Spurlock would have sentenced him in this way. Even if we were to bore that out and said that the parties did come into an agreement that they would jointly recommend, communicate to the court, this is what we've landed on, there's nothing that would have required Judge Spurlock to sentence the defendant in that way. We're not in Rule 12 of a plea with a charging concession that binds the court to either wholly accept or wholly reject the agreement between the parties. So for that reason alone, the prejudice prong cannot be met here. But certainly the defendant's showing for performance is deficient as well. I disagree with my brother that the court is not entitled to review affidavits from defendants and deem them to be in their own self-interest and biased. Here it's incredibly pertinent that the defendant conveniently cannot remember what defense counsel did advise him of at the time, but he can remember that he was specifically not advised of the strength of the Commonwealth's case at the habitual offender stage of the proceedings, the potential sentencing he would be facing if found to be a habitual offender, his appellate rights and likelihood of success on appeal, and the legality of waiver of appellate rights as part of a plea agreement. It's telling that he's clearly can remember what was not conveyed to him, but did not put in his affidavit what in fact was. In terms of self-interest, we have, though not mutually exclusive, I'd say diametrically opposed reasons why the defendant offers in his affidavit why he didn't want to go forward with this. Is it that you thought that there was some, scheme going on, that there was wrongdoing done at the hearing, at the trial, that the Commonwealth was trying to sweep under the rug, which in his affidavit he avers was the sole reason why he did not want to go forward with the sentencing recommendation? Or is it, as he also avers, that he didn't realize it was legal? Those are, very different reasons, and the defendant does not land on a specific one. Timing and delay. Again, the defendant, as was pointed out by your honors, has already reaped the benefit of the bargain, if you will, that the Commonwealth was making at that time. It's been 16 years, it was 16 years at the time that he filed this motion for new trial. He had had a direct appeal, a motion for new trial, which received an evidentiary hearing wherein he raised an ineffective assistance claim and also attacked things that took place at the habitual offender hearing. Both the direct appeal and that first motion for new trial were denied on appeal. He then filed a second, a motion to revise and revoke his sentence, which was denied, and the defendant was essentially, advised isn't the word, but was told that this is not the correct vehicle for raising such an issue, and chose to let that issue fall to the side, and then waited 11 years to then come forward with this new complaint, this new issue with how things went at trial.
What do you say about the defendant's argument that Judge Spurlock did something wrong? I mean, I'm aware of the record, I'm aware of the sequence, and I don't mean to ignore it, that before Judge Spurlock opened his mouth, the parties had already made clear that there had been an offer and that the defendant had rejected it. So I understand the good argument that whatever Judge Spurlock said at that point was irrelevant, immaterial, but Judge Spurlock nevertheless going on to say, I would not accept that deal. And I was struggling with that. I mean, sorry, I don't want to, but both parties seem to say you're allowed to waive your appellate rights. I understand you're allowed to plead guilty, and then that carries a certain amount of waiver, but you can still appeal the guilty plea on the idea that it's not knowing, intelligent, and voluntary. So help me with that piece of this?
Sure. I'll first state that I don't think the court needs to get there in this case because the performance prong issue, part of this here is clear cut. That being said, and I know Your Honor has already stated you recognize the series of events here, but I do think it bears emphasizing that, again, the defendant had reached this decision before Judge Spurlock opened his mouth. The fact that he was reassured by what he heard is frankly irrelevant to the decision-making that went into his decision not to pursue this offer. Frankly, when in researching for this brief, found in very short passing instances where a plea offer has gone through where there was waiver of appellate rights, certainly nothing that suggested it's not permissible. But again, we find ourselves in an odd position here because there was a jury trial. I did not come across a case where a judge who at that point has whole sentencing power, it's wholly discretionary at that point, it's reviewed for an abuse of discretion, but the judge is not required to take into, any agreement by the parties, any agreed upon conditions of probation, or even if the parties recommend the same sentence, the judge is not required to impose that. Frankly, I could not come across a case where I've ever seen a waiver of any sort of right as part of sentencing after a trial, because I don't really see how a judge could implement that. If a defendant's been convicted at trial, we're now at sentencing, how a judge can say, I'm ordering that you waive this right. So all of that to say, not only do we have clear in the record that Judge Spurlock would not have accepted this, and the Commonwealth's opposition to the motion for new trial, which is included in my brother's appendix, and I'll point you specifically to pages 77 and 78, does get into why, and as I believe my brother acknowledged, that there is certainly scholarly works and other positions that discourage, even in a plea position, waiver of appellate rights. So we have that one line here, that Judge Spurlock's practice would not be to accept this. But separate to that, there's no prejudice here because there's frankly not a way for this to go forward. Were the Commonwealth to have dismissed the habitual offender indictments, we don't have anything to tether a plea offer to, a colloquy to. It's frankly the Commonwealth's prerogative at that point if they want to go forward with habitual offender indictments or not. If they elect not to, there's nothing that ties the judge to sentencing in a certain way that comports with why the Commonwealth elected not to go forward with a habitual offender trial. I would point out to you, the defendant, I think, is emphasizing that he's by some way entitled to have an evidentiary hearing on this, and that the tie goes to the runner here, and he's the runner, despite there being those gapes in his affidavit. I would point the court to Commonwealth versus Marrero, which is cited in my brief. I think it's a very analogous case to what we have here, whereas a defendant who was convicted of murder one in 2005, at some point after files a motion for new trial alleging ineffective assistance of counsel, with an affidavit from himself and an affidavit from trial counsel, in which trial counsel avers not having any memory of what the particular claim was. And there, that motion for new trial was denied prior to an evidentiary hearing based on the self-serving nature of the defendant's affidavit, even though there was this gap of knowledge from trial counsel at that point, it doesn't surmount the defendant's self-serving affidavit. And that's a much tighter timeline too as well. That appeal was decided in 2011. So we're talking 6 years after the crime occurred versus here, again, we're talking 16 years after the trial took place.
Can I ask a question about the affidavit, the inference from the affidavit? So, I mean, you make a very good argument that it's very suspicious that he can remember very well what wasn't said, but he can't remember anything that was said. But how do we go from there to the fact that, well, he was correctly advised?
I think that's shifting the burden, Your Honor. I don't think that this court has to find that he was correctly advised. And I think
it's his burden to show that he wasn't.
That, exactly. I think where we're in a post-conviction posture, it's the defendant's burden to show that he was not adequately advised. So if he just falls short of what that burden is, it's not that the Commonwealth then has to pick up the ball, run with it, and establish that he was properly advised. It's essentially, and especially in situations like this where we've had so much time pass, putting the Commonwealth in a position of having to prove a negative and getting that information where it's not possible. And I think it's also worth noting here too that the defendant was given the option to testify at this hearing, which he was not entitled to by law at that point, which is, borne out further by the motion judges.
Judge Rayburn pretty much made it clear. I don't think it's going to help you if you do, but go ahead.
I disagree with that classification, but even if we do that characterization, but even if we do.
How would you characterize that?
I think in reviewing the transcript, sure, the judge does, articulate that she thinks she has the information that's necessary, but she does offer, does your client want to testify? And he says no. At that stage of it, he wasn't even entitled to that option of testifying. There hadn't been the determination that he'd raise a substantial issue justifying an evidentiary hearing on his motion. He still was given that consideration, that courtesy, and elected not to use it. And I think frankly, it mirrors what we're dealing with at the heart of this, is that the defendant makes a choice. It doesn't bore out in a way that serves him, and then we're on the other side of that, and he regrets making that choice.
How about this? I understand the defendant's already said, no deal, I don't want to do that. And then Judge Spurlock says, well, I wouldn't do that anyway because he's waiving his appellate rights. Is it ineffective, unreasonable performance for the defense counsel to say, well, slow down, Your Honor. With all due respect, we've had a trial, but he's facing the habitual offender situation, and for you to say right now, you would, and let's say this is a sentencing recommendation, all we're talking about is an agreed upon sentencing recommendation, and frankly, the Commonwealth is being very reasonable here in giving us 12 to 15 versus life if he gets convicted of what's about to happen. And so I think, Your Honor, you're being excessively rigid here in preventing the parties from achieving justice. Was that unreasonable performance from the defense counsel, acknowledging that the Commonwealth was being reasonable in its offer?
I would say no, and I recognize Your Honor's question does suppose certain facts that precede that. But I would say no because, or I think I would reframe that question into, had that exchange happened that way, would it still be an abuse of discretion for that judge to say, I recognize you're all in agreement that you all think this is fair, I don't, and I'm not going to go forward in that way. Would that be an abuse of discretion? And I think the case law does not bore out that would be the case, that it would be an abuse of discretion to say that I don't think that's appropriate.
The judge has that much, I'm not arguing with you so much as just getting clarification. Your very last citation in your case, in your brief, is the judges have wide discretion in sentencing, and you're saying that discretion goes this far. Even on the hypo I just gave you, for the judge to say, I don't care, you're in agreement, I still want to go ahead and have this habitual offender trial, which is going to result in life sentence for this guy. I refuse to accept this plea.
I think so, because then I think that puts the ball back in the Commonwealth's side of the court, right? That if the judge says, no, I'm not doing that, then if the Commonwealth feels that is necessary, then we can refuse to go forward on the indictments and dismiss the case. So I think if in that hypothetical where it's so strongly argued that this would be a failure of justice to not go forward in that way, there is still that if the Commonwealth did feel so bonded with the defendant in that recommendation, we could go forward by just choosing to dismiss the habitual offender indictments, which would then restrict what the judge's parameters are for sentencing. He would no longer, as I understand it, or I don't want to say that too, I don't want to be so assertive in that. I can't recall the sentencing guidelines for what the defendant was convicted of here. I think it was armed robbery and ABDW, serious bodily injury. I don't know if he would still be facing a full life sentence, but in that instance, following that out as well, if the judge then sentenced him to a life sentence, perhaps the defendant would file a motion or an appeal of that sentence, then claiming an abuse of discretion there.
I wanted to ask you a question in terms of the waiver, not raising it in the first motion for new trial. Weren't these claims really actually not viable until 2012 when the Supreme Court decided Lafleur and Frye?
That's a good point, Your Honor. I did not consider that before coming before you today, so I don't want to take a hard stance on that. I'm not sure. I accept your point that Lafleur v. Cooper, I believe, did, further expand these things. So perhaps in that instance, then the waiver argument wouldn't be as controlling here. I don't think this court needs to find the waiver because, again, you're still reviewing for a substantial risk of a miscarriage of justice. Were you to find waiver, but even short of that, just reviewing this, had this been its first blush in front of this court, we'd be in good shape. Lastly, just if I may very briefly just touch on the relief sought here. I recognize.
Just 30 seconds.
Sorry?
Do it in 30 seconds.
30 seconds, wonderful. In terms of the relief sought, again, I'm not sure how this court could force a trial judge to sentence after a trial in a certain way, especially where this was put in front of Judge Spurlock 18 years ago now, very informally. And I frankly don't know what then would happen to the defendant's record in terms of the habitual offender indictments. Would those now be reversed to dismissals? Would they be acquittals? I don't see how that bears out as well. So I would just make that point as well to the court. And if there are no further questions, I will rest on my brief.
Okay, no, thank you both very much. A really interesting case. And I apologize to our guests from Suffolk University Law School. I'm a bad host. I didn't welcome you to begin, but we're gonna adjourn, and then we'll be back to talk to you. So again, thank you both, and the court is adjourned.
Thank you.
Court all rise, please.